Hi, y'all, and welcome to tonight's live stream. Well, Blake Lively has been handed her first big loss in her lawsuit against Justin Baldoni. And frankly, it is entirely her own fault, or more precisely, the fault of her legal team. They were asking for too much here. It was overreaching, and frankly, it was a shocking amount of overreach. I called it out in our last video, and it wasn't even all that close. For those of you who aren't following the case yet, Justin Baldoni founded Wayfarer Studios with billionaire Steve Sarowitz, and Wayfarer bought the rights to the movie rights to a book called It Ends With Us. Now, Baldoni was a director, and he also played the lead role opposite co-star Blake Lively. Now, Blake Lively says that while they were on the set, starring together in this movie, that he SH'd her. She says when she complained, he then set out to retaliate against her by orchestrating a smear campaign designed to destroy her reputation. So Blake Lively filed a complaint with the California Civil Rights Department and then a complaint in federal court in New York. Justin Baldoni says Blake Lively was the root of the problems, that she wanted to take over control of the production, and she intentionally made false allegations hoping she could edge him out of his own movie. And it worked, according to Baldoni. He said Blake Lively is the one who orchestrated the smear campaign against him and not the other way around. Baldoni sued Blake Lively in federal court in New York. And the two cases, Blake Lively's case against Justin Baldoni's case against Blake Lively, have been consolidated into one case. And there are lots of defendants, lots of plaintiffs, lots of counterclaim plaintiffs and defendants. Discovery is just beginning in the federal case in New York. Now, after asking for this really broad request that we talked about on our last video, the Blake Lively team was given a second bite at the apple. They were sent back to talk it over with Baldoni's team before the judge ruled. Now, let me say up front that every lawyer's goal is to win the early motions. That is critically important because you are setting the tone for what the judge is going to think about you. Are you being reasonable? Or are you asking for things that you aren't entitled to? Are you complying with the court rules? Did you have a meet and confer before you bothered the court with this issue? And that was one thing that Blake Lively said that Justin Baldoni hadn't done. Things like that really matter and are important in how the court views the parties and how the court views the lawyers. So Blake Lively's team needed to be reasonable here. They wanted to be reasonable here. It was in their client's best interest that they only asked for things that the judge would rule with them on. Because later in the litigation, they will all get to some rulings that are a lot harder, that are a lot more subjective, and that matter a great deal in the case, and judges could easily differ on what they would decide about those issues. So in those discretionary rulings, you want the judge to have first and foremost in his mind that you only ask for things that make sense. You only ask for things that are reasonable. So it was a golden opportunity, and the judge withheld ruling. They had a chance to limit the question to only ask for reasonable things. But the second time, they again surprisingly missed a great chance to limit this request to make it reasonable. We'll get into all of that. We'll go through it pretty quickly, I think, so you can get an understanding of why it is that the court ruled against them and what exactly that means for the case. So when the two sides finished their meet and confer, it was still super broad, and you could see this coming a mile away. The judge ruled against the Blake Lively side, and it was just embarrassing, especially since it was so early in the case and when the judge is forming those all-important first impressions. They also asked for a protective order that was extremely restrictive, that would keep the public from finding out all kinds of things. But I think it was primarily drawn up to protect a certain megastar who is close friends with Blake Lively. Now, later this week, the court is going to hold a hearing on that very issue, that protective order. We'll cover that on a future live stream. So it does seem, though, that maybe Team Blake Lively and her husband, Ryan Reynolds, their team is maybe wising up. Will the third time be the charm? Because they now have made a much better legal move. Does it mean they're getting smarter, maybe reading the room right, or are there going to be some more missteps? We will talk about all of that tonight. So special shout out to the first 5 in tonight's chat: Abby Normal, Beth A, Chico Karen, Bama Queen, and Isabel Ruth Callaghan. Hi to all of y'all and to everybody on the stream tonight. So as a quick review, let's look at what Blake Lively was asking for. And it's very broad, as there was a complaint from the Justin Baldoni side saying exactly that. And I'm going to make it a little bit bigger so you can see. So here's what they were asking for. It was a subpoena sent to the big 3 mobile carriers: AT&T, Verizon, and T-Mobile. And the request said all documents concerning ingoing and outgoing calls or text messages related to telephone number, the number's redacted, belonging to the first one, Justin Baldoni, within the time period of December 1st, 2022 to the present, including but not limited to call logs, text logs, data logs, and cell site location information. So just to get a sense of how incredibly broad this is, they were asking for everything the phone company kept, which if they kept the actual text messages, they were asking for that. They were asking for call logs, text logs, and all cell site location data for 2.5 years. So that for 2.5 years, they would be able to follow exactly where Justin Baldoni's phone went. And they weren't just asking that for Justin Baldoni. They were asking it for all of the people you see listed here. The ones that I put in orange are parties to the case. So they actually are at least in the case, named in the case. They've been served. They are actual defendants. Blake Lively is suing them. But the other ones are non-parties. They aren't even parties, but all of that information is being requested about them from the phone company. Every text message, every phone call, at a minimum, logs of it. But if they kept more than that, even more than that. It was really broad, and length of time from 2022 until now. So years of this data, years of this information. And so there was a really easy response from Justin Baldoni's team. And let me, but before I even get into that, let me talk about what is the general rule that everybody has to follow? And the answer is that there are rules that limit how much discovery you can ask for, how much you can ask for when you go out looking for information in a lawsuit. And there are some rules that limit what kind of things you can ask for. You have to ask for things that are not privileged. I've got Rule 26B1 up here, and I've underlined 3 critical words. Things that are not privileged. And you know that there's a marital privilege. A husband and wife have a privilege as they talk to one another. Then there are privileges that relate to clergy in a lot of states, sometimes media, sometimes, always an attorney. So those things are protected. Then anything that you ask for in discovery has to be relevant, because this could otherwise become such an overreach of really serious proportions if you could just ask anybody for anything because you filed a lawsuit. It has to be relevant. It has to be something that pertains to the case. Otherwise, you aren't allowed to ask for that. And it has to be proportional. So if the case is big, you might be able to ask for more, but it still has to be connected. If it's a tiny little issue and you're asking for an enormous amount of information, the court will say no. Those are the 3 things that the court is really going to look for when it's evaluating whether or not somebody's discovery is appropriate. So here is a letter that was sent in New York. In federal court, instead of motions and longer briefs, they do letter briefs. I had a case in New York, and I can't remember which district it was. Maybe in any event, I had a case in New York, and we were limited to 2 pages for our briefs, and they had to be 2-page letters. It was brutal. I hated that because I just felt like I always needed more room to explain what I had to say. And you spent so much time trying to cut it down to that little smaller section. However, when you're on the other side and reading it, it is convenient that they're shorter. So Justin Baldoni made a pretty obvious argument. He said, look, it's hard to overstate how broad, invasive, and atypical these subpoenas truly are. And it is. It really is. That's really too broad. Just on its face, that doesn't make sense. And he says, this is civil litigation. This isn't the FBI coming in and asking for something, but they're asking for complete call and text history. That's huge. They're asking for real-time location information, data logs showing web browsing history. That is really broad, and it has no real connection to what's being asked for in the case, and it's disproportionate. That's not connected to the issues right here in front of us. It's out of sync with what that is. So all of that made complete sense, and I said that in our last brief. Now, there was briefing back and forth about that. We'll take a look at the next one. This is the response from Blake Lively's team, and they said, look, we're only asking for non-content records, that is numerical logs. In other words, they were saying if the phone company actually kept the text messages, we aren't asking for that. If they kept recordings of phone calls, we're not asking for that. We're only asking for non-content records. Problem being, that isn't really what they were asking for, the way they worded the request. So, and then they say each individual that we've asked for is either a party to this action or an agent employee of a party who appears to have a direct connection to the underlying issues. The requests are tailored to the time during which evidence shows each individual may have been involved in acts giving rise to Ms. Lively's claims. Such information is not only relevant, but essential. This is something the judge will quote in just a minute, to unearth the network of individuals involved in the alleged retaliation scheme against Ms. Lively. Despite their representations, the Wayfarer parties have failed to meet and confer in good faith prior to bringing their motion. The Lively Reynolds parties repeatedly clarified that subpoenas seek only non-content data, such as call logs. So the judge latched onto this, failed to meet and confer. And the reason that there is that requirement at all, meet and confer, is that judges really don't want to waste their time. They don't want to spend time figuring out whether or not who should get what in discovery if everyone could just agree on it. Think of the time that would save. And so judges try to get everybody to work it out, talk to each other. Don't come to me first, talk to each other first. And only after you've done that can you come to me. So the minute they said hasn't been a good faith meet and confer, he was like, okay, fine. You immediately need to go to a meet and confer. And so well, let me hold off on that. So he said, you do need to go to a meet and confer. You're going to need to discuss this and figure this out. Baldoni said, here we go. He responded or replied on this. He said, we saw what the parties said and what Blake Lively's team is saying they've asked for. But if you look at this, they're really asking for a lot more than that. They asked for all call, text, and data logs. Not just that, though. They asked for a lot more than that. You saw the request itself in there where they're asking for anything related to those phone numbers. And they're saying it's a lot broader than they're representing to you, court. And whether they're admitting, we don't know whether the providers, AT&T, T-Mobile, Verizon, we don't know whether they're going to have location data or browsing history from Google. We don't know whether they're going to have content like the actual text messages or maybe phone messages that got left. But what we don't want to happen is this just gets produced by the company, and then that's enough right then and there for the company to move forward and produce it. And then we're constantly running behind because they've already got all the information. So they're saying that's what we're worried about. And we did have a meet and confer, and it's not enough. The amount that they're trying to limit this is not nearly enough. So at this point, the judge has told everybody, I want you to meet and confer. And that's really not, and here's his order. It was just a minute order written into the docket. And he said, let's everybody talk about this first. That's a really common request that the court's going to make. There's nothing unusual about that. So at that point, they go back and meet, and the Baldoni parties are still not happy. What they're saying is, okay, they agreed to withdraw the really broad stuff like all documents and data logs and cell site location information that were just crazy. But they're not withdrawing the request for call and text logs. And the problem with that is that it includes a lot of information that has nothing to do with this case. Because if you think about the number of calls and texts you made over the course of 2.5 years and how many different people and parties you have contacted, for any of these people, including the defendants, the number of people who were involved has got to be tiny. And the number of calls and text messages that relate to this case, 1% maybe? And not, in other words, 99% has nothing to do with this case. And they're saying if what you let them do, Judge, is get this entire log, they can look it up. They can say, okay, reverse phone lookup. Let's look at the number and let's find who that was a call to. And they can determine an awful lot of private and completely irrelevant information, like how many times I called my counselor or what doctors I communicated with. And you can see where some of that could be really problematic. Let's say that you called a doctor, a cardiologist. Then maybe they would conclude after your 8th phone call to the cardiologist, maybe you have a cardiology problem. Well, if you are concerned about your ability to take a new role, then them leaking that information could end up really hurting you. So that's the kind of thing they're saying. This is information that isn't relevant and that they should not be allowed to get. That's not fair, Judge. It's not appropriate in this circumstance. So the parties for Blake Lively, this is Blake Lively's side, said, well, look, this information that we're requesting is not any kind of private information. It's not privileged information, just the fact of a phone call from one party to another. We won't know what's actually said during the phone call. All we'll know is that this person called this other person. That's all the information we're going to have. And that isn't in and of itself private or confidential. And so they said, we're modifying it. We're going to make it smaller. We're going to make it more tailored. So we're just going to ask for non-content numerical information. And that's totally fair. So the judge issued this order in which he ruled first of all, very correctly. And secondly, he ruled very clearly in favor of Justin Baldoni's team. Now, it says at the top there that the motion was granted in part and denied in part, but wait until you understand what part was denied and why. It's not that the judge said, I don't agree with this in any way. That isn't how it worked. So let's move down to this section. Okay. So here's what the judge said. He said the subpoenas that Blake Lively's team is trying to put out, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. And remember how we said at the beginning, I was saying these are really broad. These are too broad. It was exactly what Justin Baldoni's team said. And he says, the judge, this request implicates legitimate privacy interests, even though Lively has narrowed her request to exclude the content of calls or messages. The phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer party spoke to and when. Lively mainly argues that the subpoenas will help to identify the larger network of individuals who perpetuated a negative media campaign against her. But according to Lively's complaint, this negative campaign did not begin until approximately August 2024. Remember, this went all the way back to 2022. It is therefore unclear how communications to and from Wayfarer parties in 2022 and 2023 would reveal individuals who participated in the campaign. More generally, Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests. Lively's complaint already identifies many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. And that seems obvious enough, right? Even if they found that there were repeated calls from Justin Baldoni to a particular person, that's not going to give them the information about whether that person participated in the campaign that they allege occurred against Blake Lively. It's only going to tell them there were 22 phone calls from Justin to person A. That's all they're going to know. And so they've already identified a ton of people, and it should be limited to those people. That's all that should be requested in the way of phone information. They said, the judge said, look, I'm going to rule this way. You can come back and narrow this. You can ask an appropriate subpoena, but this is too broad. But the judge then said, look, the Wayfarer, remember I said it was granted in part and denied in part. Here's the part that was denied. That the Wayfarer parties, that's Baldoni's side, have not demonstrated standing to object to the subpoena request seeking the phone records of non-parties. Now, what does that mean? Standing means you have the right that's being violated, or you have the ownership in the thing that's being taken or that someone is seeking. You have the ability to actually petition the court about that. You have standing. You are the person who has the right to talk to the court about that. And the court is saying, look, Baldoni's team, if these are requests made for a third party's phone records, then that's really none of your business, Baldoni's team. It's their business. And you can't come to the court and say, oh, I don't want AT&T to produce records for Jane Doe, because you're not Jane Doe, and only Jane Doe can come and petition about that. And he then said the Wayfarer parties may assert a privacy interest in their own phone records, but they have not provided any basis for asserting an interest in the communications of non-parties. Now, I actually disagree with this ruling a little bit. I think it reaches the correct result as far as all of the Baldoni parties. I think this was crazy too broad, but I don't think it makes sense. And I'm going to, I haven't been showing you this all this time. My apologies. I will add that back. Okay. There we go. And now, actually, what am I doing? I'm going to go ahead and remove it because for now, I wanted to talk to you a little bit. I think that the bigger issue is not the privacy or the privilege and figuring out that maybe the person is calling their doctor or their psychologist. Certainly that can be embarrassing. Let's say you found out somebody called the marriage psychologist, 42 times in 5 months. Maybe that would give some kind of indication that there was a problem with the person's marriage. And that's not the business of the Blake Lively party. So I agree that that is a private interest that doesn't have any, and this is the bigger thing to me, it doesn't have anything to do with this case. And most of the phone calls will have nothing to do with this case. And so it ought to be, to me, the issue is relevance. Like, is this connected to the case? Do they have a reason and a right to ask this question? And the answer in this particular case is that they don't have a right to ask for anything that isn't relevant. And that's true whether they're asking for Justin Baldoni's records or a third party's records. Justin Baldoni does have the right to tell the court and to ask the court to stop them from seeking discovery that's not relevant, even if it relates to a third party. He doesn't have the right to assert their privilege or privacy interests. But in this particular case, making a ruling like this that limits Justin Baldoni's ability to cover this to only those cases where Justin Baldoni himself is actually at stake, only he and the parties his legal team is representing are making this motion, I think doesn't allow them to tell the court that AT&T, Verizon, T-Mobile should not be producing these records at all because they're not connected to the case. They're just irrelevant in the case. So I would have made, if I were king of the world, I would be making a much broader ruling that would allow Baldoni's team to also argue about whether or not third parties were allowed would have to come in and make their rulings make their arguments themselves. I would let Baldoni do it. But in the end, it didn't matter, because here is what is about to happen. Let me add this and add it back to the stage. Okay. So right on the heels of this, the Baldoni team said, okay, well, one thing, Tort, you need to know is some of the people that they want to ask for AT&T records for, or whatever phone company, are non-parties: Tara Hanks, Milika Toskovic, and Jarice Blackman. And those people work for us. They work for Wayfair. So we do have the ability to object to anything related to them. And then on the heels of that, the judge said, okay, stop everything in an order, said, let's talk about this. Nobody produce anything pursuant to the subpoena. Nobody enforce the subpoena until I can hear from everybody. And then on top of that, there were two more of the people who were on that list I showed you, and I'm going to show you the list over again. Catherine Case and Brianna Butler Koslow, who both came in and said, okay, we are third parties and we just want to assert our rights. Now, Judge, you've already ruled that these are violations of privacy rights. So we're here and we're saying we want you to rule for us too that these are privacy rights. Now, so this is where things stood. The ones in darker orange are the people who are parties. But now we've added to that the three in the lighter orange. Those are ones who are employees. And we've added the two in kind of the salmon color. And those are people who are now filing requests. So there are only three people left, right? Matthew Gibson, Matthew Mitchell, and Henry Hargitay. That's it. Those are the only people who are left. Everybody else has opted out of this or taken advantage of what the court had to say. And so then Blake Lively's team did exactly what it needed to do, which is it said, look, we've gotten these and we've heard about the third parties who were about to file at the time they filed this, I assume. And they said, look, what we've done is write to all of the providers and just say, we give up. We are withdrawing those subpoenas entirely, and we're asking you, the court, to deny the motion filed by those parties, deny it as moot. Today, that happened. The judge denied the motion to quash all of this. That means to squash it, basically, to prevent these from going forward. And the judge said, we're denying all of this. The judge said it's going to be moot now because it's been withdrawn. There's no need for me to rule on this anymore. And that was, in a nutshell, how Blake Lively lost her first motion. And the reason I think this matters is not because it's a super critically important issue. I think it was crazy overbroad. It's just that it sets the stage and the tone for how the judge is going to perceive everybody. And the way I think the judge will perceive them is, this is crazy overbroad. This is really way too broad. This request was not appropriate, and therefore it's something that the judge ruled against them on quite easily. There was a question of maybe whether they had standing, whether or not Baldoni had standing to make the argument for some of the third parties, but they quickly came on board and Blake's team ended up just withdrawing it. Now, at that point is where things turn around, I think, because having withdrawn that, I think, was definitely the right move. And obviously, a single misstep doesn't completely change the way the course of the litigation is going to go. But it is unfortunate for the Blake Lively team, because I think they did get off on the wrong foot with this request that really made no sense. It just was not appropriate. And Baldoni's team looked very reasonable because they were absolutely right. It was a pretty easy ruling for the court and for them. All right, so let's, I'm going to go with some questions, but I have a few people to thank. Spunky, thank you so much for gifting 5 lawyerly memberships. I appreciate that very much. We will be having our next members only event probably next Monday night. So put that on your calendars. And Wendy, thank you for the super sticker. I appreciate that. And Michael Lalonde has been a member for 11 months. Congratulations. And we are delighted to have you for 11 months, Michael. Thank you so much. All right. So let's head over and look if there are some questions. Oh, forgot to say, if you would put your question marks at the beginning, it will be a lot easier for me to spot it in the chat. So that would be a big help. Okay. So I see where people are. So I'm looking for question marks at the beginning. That's my best shot. And while we're doing that, I have, and while y'all are putting those in, I'm going to add to the, add to the stage, and it'll take me just a second, but I want to make sure that I have us all teed up, and this will give you time anyway while you're putting your questions in there for our outro, which I forgot to put in. All right, here we go. So this, when you hear it, wait, nope, we're not stopping. I just needed to make sure it was in the file here. Okay, so here we go. Question marks at the beginning. And IO5 says, will the Baldoni team request years of material too? Sorry if already addressed. No, it hasn't been addressed. And absolutely, they will request similar timeframes. In fact, I would assume they'll key off one another. The question is, what are you requesting for that period of time? If what you asked for was every text message Justin Baldoni sent to Blake Lively for this period of time, that would make a lot of sense because they were working together on this project. They didn't really have anything else going on, and they worked for a limited period of time. So that would be pretty easy. But if what you said was every communication you've had with, for the last 10 or 20 years, and either side, that's going to be overreaching. They're both going to have to limit it, and they're both going to have to attempt to be reasonable. So that is something that I expect both sides to be asking for similar periods of time that would fit when these parties work together. And it's pretty limited, really, a couple of years. Sprout wants to know, will the subpoenas be released to the public? They have been released to the public. The document I put in, the very first document I put in, was the actual subpoena. Now, you are probably wanting to know more than just was the subpoena itself released. And you're probably wanting to know, will the information that gets produced because of the subpoena get produced to the public? Will the public get to see that? And in this particular case, since they've withdrawn the subpoenas to the 3 phone companies, obviously there's not going to be anything produced, and no, we won't get to see that. As things go along and there are requests, I believe that there's a lot of it we will not see in the public, and that's because there's going to be a protective order entered. The parties are arguing about that now. The judge is going to take it under consideration on Thursday. The 2 parties have some pretty different ideas about what they think the protective order should include. So they're going to argue about that on Thursday, and I will let you know what happens. That'll be another live stream we'll do here. Johnny Hartley wants to know what you're thinking about this going to court. Will it, or will they settle out of court? Well, Johnny, that's a pretty clear answer in terms of statistics, which is just statistically speaking, the vast majority of civil cases are going to settle without going to court. In this case, the parties have extra reason for that to be the case. They have extra reason to settle this. And that's because they do have very public personas, very public images. They want the public to like them and want to see them in films. So that is something where they've got to consider that at every stage. What is my reputation? How am I looking? And it's not just their reputation, but it's the reputation of the people who are witnesses and who are part and parcel of this, because this dispute is going on. So that would include Taylor Swift, who is allegedly Blake Lively's close friend, is Blake Lively's close friend, and who allegedly was present at a conversation or two. We're going to cover that on another live stream. So then there are also co-stars of the 2 who might testify, who were there, present, saw things between Blake Lively and Justin Baldoni. There are some Blake Lively has referred to, but without actually giving names in her amended complaint. She said, well, there are people who will support me. There are other people this happened to, and she withheld the names. So all of those sorts of things those are people who want privacy. Those are people who don't want to go to court. So there's a lot of pressure in a case like this to settle before it goes to court. On the other hand, there will be some need for everybody to save face. So I am personally a mediator. So one of the things I do is work out how can these parties resolve this case without going to court. And so I take my trial experience and put that to work on how they can handle this. So that's exactly what a mediator will be doing is, okay, what can we put together to give everybody a chance to get out of this case and save as much face as possible so that we can get this over with. So my guess is that they ultimately will settle without trial, but we will see. I was certainly surprised that Johnny Depp and Amber Heard went to trial, so who knows? B wants to know, are certain privacy rights protected by law no longer protected when it comes to a criminal investigation? So there are limits to privacy rights, and it depends on kind of what privacy we're talking about. This particular case is a civil case, not a criminal one. And I'm sure you're just asking, more broadly. So certainly there are privacy rights that get limited. But not privileges. Privileges are still going to apply, like the privilege between a husband and wife or an attorney and a client. Those would still apply. All right, looking for question marks at the beginning. Rosie asking, what are you covering next? And suggesting, I always enjoy when y'all suggest cases for me to cover. I'm trying to narrow my focus because I find absolutely everything interesting, and that's really a hardship because I think it makes me more scattered. So I'm trying to focus in on a fewer cases, but I love researching these, and I am always interested because I'm always looking to figure out what do we need to cover next. So Rosie is suggesting Timothy Halsett in Missouri, the Blue Barrel Killer. I haven't heard anything about it. Sounds like an interesting title, the Blue Barrel Killer. Sounds like a novel, doesn't it? Interesting. IO5 wants to know, do you believe the claim of failure to investigate Lively's HR complaint has legs? And what is the remedy? So I don't know the answer to that. I mean, I don't really know what specifically she complained about, and I don't know exactly what they did. And that's all going to have to be tested during the discovery. They'll have to depose people. They'll have to look at the documents. And I think it's really hard to answer that question without that information. I think it's even hard for the parties. That's exactly the stuff they're going to be trying to pull out and understand as they move forward. So in terms of the remedy, in this particular case, the remedy everybody is seeking is financial damages. This is, they're not looking for remedies like reinstatement or something like that. That doesn't really apply here. So they're looking specifically at monetary compensation to the people wronged. That's what both sides are requesting. Oh, Bone Mama, thank you for gifting 5 lawyerly memberships. I appreciate that very much. We are really looking forward to, we are going to be, honestly, we have the most fun of any membership program on YouTube. I have no question about that. We are going to be writing our very own true crime novel, AI assisted true crime novel. So we did a little practice run with a short story. And I'll be putting that out for you shortly, but we will be, and you can hear what we came up with. But the members are going to help me figure out, okay, what are our parameters? What are the things we want to happen in this? And then we will be using ChatGPT to assist us with figuring out some of this. So I'm really, really looking forward to it. Okay, so I am looking for the question marks at the beginning. I got distracted there for a minute, but I am very excited about Bone Mama's gift and about all of our members. Chameleon Strikes asks, is talking about another YouTuber under a smear campaign and doesn't have resources to take legal action. Is there anything she can do to protect herself? And as far as I think that there are allegations that both sides in this case are engaged in all-out media PR war, and that they want to, both from the beginning, have said the other side tried to smear me, this side tried to smear me. And so those are continued problems. And that certainly has spillover to other people and to anyone who might report on this. As far as the legal action, I think it's really, I hate to do this, It depends. The lawyer's answer, it depends. It depends on what exactly is happening and what evidence they have about what's happening. And so I honestly can't say. It's a good question and very interesting. Hey, Ruby says the Baldoni team not put forth a motion to dismiss it. And to be clear, I don't know how to pronounce the name of the YouTuber Flaw, but I have been watching her videos. I have seen some of those that are very interesting. Hey, Ruby says the Baldoni team not put forth a motion to dismiss the action against them. Does this mean they want to go forward? So it's a question of timing, I imagine. That I don't think theirs has been due yet, and so they have plenty of time to still file that. It's very classically typical for both sides to file a motion to dismiss if there are counterclaims. That's just kind of normal. If it's appropriate and they think it could actually get the claims dismissed, it rarely does. Sometimes there will be some claims that aren't appropriate. Maybe there are 8 claims and the judge will toss out 2 or 3 because they weren't really quite right. They weren't really quite fitted to the case. So that does happen. But for the most part, a motion to dismiss is rarely granted. It's not a real common thing. Okay, Johnny, I know it will have to be an estimate, but how much legal costs a month? Wow, would you estimate each side is having to pay? Johnny has seen an estimate of $1 million a month. That wouldn't stun me. I would think that these are New York attorneys. That's the most expensive place for attorneys in the country, I believe. So I wouldn't be at all surprised to hear that $2,000 an hour for multiple of these attorneys. And they have a lot of attorneys. They have a lot of parties and a lot of attorneys. And remember, it's not just Justin Baldoni and it's not just Blake Lively. It's all sorts of people connected, each of whom probably has a personal attorney involved. And then there are third parties who have attorneys. So it's going to be massive. Cost, I don't even know how I'd estimate it, but we'll just go with a lot. It's going to be a whole lot. Ryan asked me if they settled, who would pay who, and are they suing each other? And Ryan, the answer is yes, they're suing each other. Blake's side with lots of plaintiffs is suing Justin Baldoni's side with lots of defendants, and then vice versa. He's suing her faults. And so, yes, they're suing each other. As far as how do you figure out who pays this side, who pays that, how does it work? It's going to depend on where things shake out after the discovery. So as they begin to find the facts and start to find out how effective the depositions were, did they get some really good information? Are they going to be able to use this? The closer they get to trial and the more they can tell about how much they've been able to really further the case, so it looks like they are going to be able to take the case and win, that's the side that's more likely to get paid. Remember, in the Johnny Depp Amber Heard, you had the same sort of issue. They both had cases. In the end, the jury awarded some damages to each side, and they offset, and Johnny Depp got much more than Amber Heard did. But both sides got something. It's kind of like that. In a mediation, they will settle it and figure that out as to who pays who's going to pay, what's going to be paid, and how it will get paid. All that would get worked out. If it's done at trial, then a jury will decide all those claims, and then they will probably be offset against one another. So if Blake Lively won $1 million and Justin Baldoni won $2 million, there would be a payment of $1 million from Blake to Justin. Now, obviously, there's a lot around that. For example, appeals that I haven't mentioned, but that's just in general how it would work. All right. Chameleon Strikes asking about Kirsty Flaw, again, about the smear campaign. And I don't know about that, but that is terrifying. That is a terrifying thing. Okay. Kimberly G, how does the writing work? Does it look like Mad Libs? Oh, Kimberly is asking how we were doing the writing. So no, we wrote like a true story. And then I read it back to all of us. Marlon is doing some work on the video side of it. So we're working on it. I am the holdup. It is not Marlon who is the holdup. So if you're wondering, like, where is our short story? It's coming really soon, but it's a real short story. So you'll actually hear a little story. And it was so much fun. It was really a great time. You definitely want to become a member. You can hit the join button, by the name of the channel. Right below this, it'll say Lawyer Lee, and there's a join button, unless you are on your iPhone. And if you're on your iPhone, you have to wait until you're at your computer, or you can go in, instead of through the YouTube app, you can go in through Safari or Chrome, whatever you use, and you can join that way. The join button should appear then. Some kind of dispute going on there. I don't know exactly. I don't know why they do it that way, but it is the way it is. Okay, so looking for question marks at the beginning. Here is Maxine asking about the Delphi case. So, and I haven't posted on that in a little bit. There has been a response from the prosecution to the motion that was filed by the defense, and we covered that. The prosecution motion is giving more detail about the criminal inmate, the inmate who has supposedly, Andrew Baldwin filed something saying that this information was not shown to us or given to us. It should have been included, and it would have been evidence that there were third parties involved in the murders of the two girls, and it not, excuse me, not just Richard Allen. The prosecution has said, look, this guy was super unreliable. That's why we didn't pay any attention to him. And in addition, he has said that Richard Allen was one of the people who killed the two girls, but that there were other people involved. So I haven't read the prosecution's response yet, but that's in general, I think, what's going on. So I am a little bit behind myself, but it is super interesting, and I would like to know more about it. Tila, if the Lively Party had evidence of SA, wouldn't they have had to produce it already? Not yet. They have both filed very detailed complaints, and they put a ton of facts into those, ton of text messages, a lot of information, much more than you would normally get when you see a complaint being filed in the case. But as far as what questions are going to ask each other in discovery, that's still to come. They're just now starting on that process, and it will be several months, maybe even more than a year. They will be taking depositions. They'll be asking questions of each other. The subpoenas you saw were sort of the first venture into that, where they were going to ask for discovery from a third party. Blake Lively's team was. But now, so as far as the evidence, it's all going to come out over time. So at this point, what we have is the evidence that Blake Lively thought was so favorable to her and so important that she would put it in her complaint. And for Justin Baldoni, the evidence that was so favorable to him and so important that he would put it in his counterclaim or his complaint. I think he filed separately, but in any event, they're consolidated now, so it'd be a counterclaim. As those different claims are one-sided right now. The other side hasn't had a chance yet to test them. That's going to happen over the next months in the discovery, and we'll be following that to the extent we're allowed to see it. What the judge decides about this protective order will frankly let us know about just how much we'll get to see. It's still going to be a lot under protective order. Both sides are in favor of that, but just how much we get to see, we will find out more about that coming up after the next hearing. All right, so remember, we go live Monday, Wednesday, and Friday at 7 p.m. Eastern. I will be live Wednesday night at 7 p.m. Eastern. I don't know exactly what case I'll be covering, but later this week, I will cover this case again as the judge hopefully makes a decision, but at least has a hearing that will tell us more about the protective order that he's going to enter in this case. So I will see you all Wednesday night at 7 p.m. Eastern.